proceed, but again, we are recording this. But good afternoon to those of you who have been able to join us today for the COVID-19 and its impact on Ohio employers webinar. I'm Julie Sanderson. I'm the event director for the Toledo Regional Chamber of Commerce. So you can see that my job has been one of those that has shifted a little bit. But for over 125 years, the Chamber has been a trusted source of business information. And during these times, that's really no different. And that's really due in partnership to with members like RCO Law. Today's webinar is presented by RCO Law, a legal firm with 140 years of legal experience and with 5 offices in Ohio and Michigan. We are truly grateful for their update today, as we know that things during these times are changing sometimes on a daily basis. As I mentioned, this webinar will be recorded and it will be posted to the Chamber's website page in our member resources spot and on the RCO Law website. Just a few housekeeping things. Jeff Schaff will be our administrator today, and he is going to mute everybody for the presentation just to reduce that background noise that we have. If you have any questions during the webinar, you can handle those in one of 2 ways. You can put that in the chat box to everybody. Somebody else might have that same question. Or you can find Jeff Schaff's name and send your question to him independently. And that's if you feel like you want to remain anonymous on that. And then Jeff will ask that question on your behalf. So there are 2 ways to do that. We will hold questions until the end of the presentation, but again, you might have something that sparks your thought process while it's going on, so feel free to use that chat function. When we get to the end and it is time for questions and answers, Jeff will unmute everybody, but if you would mute yourself and then just unmute yourself when you have a question, again, that just sort of helps reduce the background noise. But with that, I'm sure many of you have done Zoom presentations and webinars, you know, through this process, so I'm sure none of that is new to you. But I do want to introduce our presenters. We have with us today Bill Beach and Amy Luck. Bill has over 30 years experience practicing employment law and employment-related litigation at RCO Law. He works with clients in Ohio ranging from Fortune 500 companies to local small and mid-sized businesses and not-for-profits. So a wide array of experience with that. Amy is an attorney practicing labor and employment law at RCO Law. She provides legal support to human resources departments and throughout Ohio and Michigan, advising clients on benefits questions, employer and employee issues, and business related litigation. So again, their experience and expertise is really appreciated today. So really with that, I will turn it over to Bill and Amy.
Very good. Thank you, Julie. And as you might guess, I'm Bill and not Amy. I will be basically presenting the first half of our program, and then Amy will follow up with the second. And what we're going to try to do is I'm going to lay out the law for you, some of the regulations, and some of the edicts out of both Columbus and Washington, D.C. And once we wade into that deep, dark forest, we're going to let Amy lead us out by answering 10 of the most important and most frequent employer questions that we're getting. So without further ado, let's move to our second slide. And bear with us because of the remote nature here and 2 people working on this. We'll have 2 people working on slides. So one of us will be saying, move it forward, please. So at the federal level, meaning these are the laws coming out of Washington, D.C., the 3 primary laws that have already been enacted are listed on this slide. And as you've heard in the media and talk shows and probably other seminars and discussions about the COVID crisis, the federal government has been referring to a phase 1, phase 2, phase 3, and I thought it might be helpful just to put those phases up in this PowerPoint with each of the laws that it's connected with. Now, the phase number is not a part of the name of the law. It's just a reference point for those in the government and those of us in the industry that, or the industries that work with these laws. So the phase one was a March 6th law passed by Congress and signed by President Trump, and it was the Coronavirus Preparedness and Response Supplemental Appropriations Act. That was the first federal action legislatively on the COVID crisis. Now that law does not really impact employers and the employer-employee relationship directly, so we're not going to spend much time on it. Phase two, however, the Families First Coronavirus Response Act, which I will also call the FFCRA, that went into effect on April 1. It was passed into law on March 18th, but it was effective April 1. And most of us in the legal industry thought it was going to be effective April 2nd, but in fact it was effective April 1st. And that may make a difference for some of you that had employees go out on leave on April 1. So be aware that that effective date for the FFCRA is April 1. So 9 days later, after the Families First Coronavirus Response Act was passed into law, phase three, or the Coronavirus Aid, Relief, and Economic Security Act, and we'll just call it the CARES Act, was passed and became effective. Now, these three laws are in place without question. And Amy, if you'll move to the next slide, you can see I've got a phase 3.5. And you can see that it was passed by the Senate just 2 days ago by a voice vote. It has not passed the House of Representatives, although we are anticipating that they are going to act on it maybe as early as this afternoon, or if not, tomorrow or over the weekend. And it's being called phase 3.5 because it essentially just funds the Paycheck Protection Program with additional money. And as you'll see when we get into the discussion of the laws, the Paycheck Protection Program falls under the CARES Act. So this is a law that has not passed all chambers of the federal government yet, but you can see this is very much an evolving process. We are at the outset of this coronavirus process as it relates to employers and employees. What we're going to talk about today is going to impact your place of employment, I hope only through the end of this year, but if litigation is to ensue, it could go on for years. So understand that it is very fluid and we are trying to keep up with it. Unfortunately, if this was held at 6 o'clock tonight, I may have an answer for you as to this Paycheck Protection Healthcare Enhancement Act, but it's only 1 o'clock, so we don't have the answer yet. And you can see I've got a phase 4 up there with a question mark. I believe there is going to be a phase 4. It will involve a tremendous amount of additional spending. What I've been hearing is the spending will be quote unquote infrastructure related in an effort to get the economy back going. But those are the 5 phases, being phase 1, phase 2, phase 3, phase 3.5, and phase 4 that we're looking at. Phases 1 through 3 are enacted and in law. Phase 3.5, I mean, we're literally on the edge of that, which could happen later today. Now moving to Ohio, there are several critical orders that have come down from the governor, and he started on March 9th with an executive order declaring a state of emergency. You can go online to the State of Ohio webpage to view these orders, or we've got them posted on our website through our COVID-19 link. So if you have questions about that declaration of emergency, I encourage you to go there to look. The other 2 executive orders that address employment issues were the emergency changes in child care rules, because I know a lot of you in the workforce have children in child care or school, and those rules were loosened to allow more people to care for children. That's all I'm going to say about that, but that does have an impact on some people's lives tremendously. And then on March 16th, Governor DeWine made some executive changes to Ohio's unemployment compensation restrictions. Namely, he got rid of the 1-week waiting period to receive unemployment benefits. So all in all, there have been 13 executive orders from the governor of Ohio to date, and there have been 2 critical orders from the director of the Ohio Department of Health. They're very much related. Essentially, the stay-at-home order that was given on March 20th, 2020, and updated on April 2nd. So the first two slides were dedicated to laws coming out of Washington, D.C., or the federal government. This slide just addresses some of the executive orders and director's orders that have come out of Ohio. So we have to pay attention to both the federal and the state level. And of course, what's any good government action without a whole lot of new acronyms? And I'm not going to read these to you unless you really have a problem with insomnia. But what I've done is put the new acronyms that have come into place since the COVID-19 crisis started. Those are in red. Some of the other acronyms that are in black you may or may not be familiar with, but I wanted to give you a resource, place to go, because if you get confused looking at publications or materials or forms as to what an acronym may mean, I'm hoping this helps. Amy, yeah, you'll see here we have a second page, and we'll also have a third page. But note here, go back one if you would, Amy. The second and third items down, those are existing laws which have been around for a long time, one since the 1930s. If you have any question about whether you are in the employment category of fewer than 500 employees, that's where the Fair Labor Standards Act and the Family and Medical Leave Act are going to come into play. Now, the Family and Medical Leave Expansion Act that we're going to talk about expands leave under certain circumstances. It does not change the application of the FMLA as it was in existence before the COVID-19 crisis. So if you have a question about counting, understand that the Fair Labor Standards Act and the Family and Medical Leave Act will come into play. Otherwise, we're going to focus on the new laws and the new acronyms in red. I think we have one more page of those. And oddly enough, the 4 new acronyms on this page, 3 of the 4, relate to unemployment compensation. I'll touch on that shortly. But probably the critical issue that everyone is facing today is the PPP, or the Paycheck Protection Program. As you can see on the screen here, it's part of the CARES Act. And that is what we are looking for additional funding from this afternoon. As you're aware, last Thursday, a week ago today, the Small Business Administration, who administers the Paycheck Protection Act, just quietly put up on their web page, we're no longer accepting applications, funds have run out. So the initial funding is gone, and we're hoping for additional funding in that phase 3.5 that we talked about earlier. Okay, let's get into the laws themselves. Again, this is phase 1, and it really does not affect the employer-employee relationship. It was just funding for different federal agencies, or additional funding, specifically to address the coronavirus outbreak. So that's all we're going to talk about with phase 1, but I wanted you to know what it was and know that it does not directly impact the employer-employee relationship. Now, phase 2 of the federal government response is the Families First Coronavirus Response Act. And within that act, there are several divisions, and those divisions are also individual acts for purposes of the overall law. And what we're going to focus on is Division C, the Emergency Family and Medical Leave Expansion Act, and Division E, the Emergency Paid Sick Leave Act. So those are 2 parts of the FFCRA that directly impact the employer-employee relationship. Now, under the FMLEA, what you get as an employee is up to 12 weeks of job-protected leave. Of this leave, the first 10 days can be unpaid. It doesn't have to be. If you're a benevolent employer, you could pay this. And as you'll hear later, there is another method under which employees could get paid for this time. But the FMLEA provides for this 12 weeks of job-protected leave. And to be eligible, you have to be a full or a part-time employee who's worked at least 30 days. So they're not rigid eligibility requirements. Now, what I want you to focus on here is under the FMLEA is there's really only one reason or one purpose that this will come into play. So don't let it confuse you with all the different leave acts that you're going to hear about and all the different acronyms. The reasons for leave essentially relate to if you have a child, a son or a daughter, who is place of school, place of care, or their child care provider is unable to open or stay open because of a public health emergency, meaning COVID-19, then they are eligible for the Family and Medical Leave Expansion Act. And that is the only circumstance where this comes into play. So if you have very young employees with no children, you don't have to worry about that. If you have employees that are, well, my age or so, you probably don't have to worry about that. But this one is limited to childcare, school, and childcare providers being unavailable for an employee's son or daughter. That is the focus of the FMLEA. Now, if they are a qualified employee, they are eligible, what you're required to pay them after the first 10 days, and of course, we're assuming a 5-day work week, so after the first 2 weeks, is not less than 2/3 of the regular rate of pay. And regular rate of pay is a term of art in the Fair Labor Standards Act that I hope we don't have to get into with any of you. But if we do, that's where we will look for defining the regular rate of pay. But as an employer, you know that the amount of paid leave cannot exceed $200 per day, which equals dollars times 5 days per week, $1,000 per week, or 10,000 in the aggregate. So you have 12 weeks of leave. The first 2 weeks are unpaid, and that leaves a $10,000 maximum on the payment to employees who are off on FMLEA, which is again tied to school unavailability, childcare unavailability, and childcare provider unavailability. Again, the threshold for this, it only applies to employers with fewer than 500 employees. Now, the other type of leave that we have is the Employee Paid Sick Leave Act. This is the second division of the FFCRA, and this provides employees with up to 80 hours of paid sick leave. And it is for full-time employees, though full-time is not defined in the Act. Now, if you're wondering why they use 80 hours here and referenced for the FMLEA weeks, I can't explain that. But together, if someone were to be lucky, they would have 12 weeks of potential paid leave. But for the purposes of the EPSLA, it's a maximum of 80 hours of paid sick leave for full-time employees. And again, to be eligible, it's a little bit different here and a little more defined. Well, I mean, the eligibility for the leave, not for the employment status, because the eligibility for the employment status is pretty much wide open. You just have to have been employed for a certain length of time to be eligible for this leave. Let's move on to the next slide. So remember, we're still talking under the Families First Coronavirus Relief Act. We talked about the Family and Medical Expanded Leave Expansion Act. Now we're talking about the Employee Paid Sick Leave Act. Those are two acts within the FFCRA. And this is where we have 6 different categories under which an employee can become eligible for leave. Obviously, number 1, the employee is subject to a quarantine or an isolation related to COVID-19, which of course raises the question, well, is the Director of Health's stay-at-home order a quarantine or isolation? In our opinion, it is not, because nobody is actually quarantined or required to isolate. All of the essential employers and employees can still go out, so it's definitely not a quarantine or isolation. And people are still, for example, allowed to go to a grocery store or a gas station if necessary. So we don't think that the director's stay-at-home order qualifies employees for leave under item number 1. Now, under item number 2, if the employee has been advised by a healthcare provider to self-quarantine, they also qualify for the EPSLA 80 hours of leave. Again, we don't know all of the answers here, but we think with telehealth, if the employee gets information about they're at risk or they are presumed to be COVID positive, that may be enough. And with today's news, this morning I heard there are several free testing places opening up here in Northwest Ohio. And I believe it was on WTOL that I saw this, but again, that information was breaking as I was getting ready for this presentation. So you might check those websites. All right, the third reason for leave under the EPSLA is the employee is experiencing symptoms of COVID-19. And, the word "and" is important, is seeking a medical diagnosis. Now, every one of you in the audience that is an employer or in HR, you're thinking of a handful of employees right now. Even though I can't see you, I can see the thought bubbles above your head, picturing the employees that you know are going to say, I think I'm experiencing symptoms. But you can say, that's fine, seek a medical diagnosis. So that would be the third reason they can seek leave under the EPSLA. The fourth reason is to care for an individual who is subject to a quarantine or has been advised by a healthcare provider to self-quarantine due to COVID-19. The fifth reason is your employee is caring for a son or daughter. Again, this is going to sound familiar because the school or place of care for the son or daughter has been closed, or the child care provider of the son or daughter is unavailable due to COVID-19 precautions. That sounds familiar. It should, because we talked about a little bit under the FMLEA. And I'll have a slide on that intersection here in a minute. But right now we're focusing on the 6 reasons why employees can get EPSLA leave, which remember is up to 80 hours of paid time. The final reason is the employee is experiencing any other substantially similar conditions specified by the Secretary of Health. Now, unfortunately, I see this item number 6 as being one that could be subject to a lot of litigation, because anytime you use a phrase like reasonable, as used in the Americans with Disabilities Act, what is reasonable to the employer and reasonable to the employee are going to be 2 different things very often. And here in item number 6, what condition is substantially similar to COVID-19 is going to be probably different to different definitions by the employer as compared to how the employee would define it. The goal is to avoid being the one in a named court case that's fighting over these definitions. Those are the 6 methods under which, or 6 reasons an employee can take EPSLA leave, which again allows them 80 hours of paid time.
Hey, Bill, we do have 2 questions that I think might be worth answering real quick.
Okay.
The first one is, would you categorize self-testing at Rite Aid as seeking a medical diagnosis under Reason 3 for Employee Paid Sick Leave Act?
I would at this point, but I would ask for documentation.
Okay. And then the second question is, are part-time employees eligible for the EPSLA?
Now, if you'll go back one screen there, Amy.
Yep.
No, make it 2. Now, you'll see it's only the second bullet point down. It's only, this part is only for full-time employees. The EPSLA is only full-time employees.
Thank you.
Okay. Now we can jump back forward. There we go. Now the amount of pay, after you look at this for a little bit, you'll start to see where things make a little bit of sense, even though it's probably very confusing today. The 6 reasons that I gave you from the prior slide, and the prior slide will be one of the ones you probably go to the most. Of those 6 reasons, if an employee is off for reason 1, 2, or 3, they get up to a maximum of $500 per day and $5,100 in the aggregate in pay. $511 per day times the 10 days that they get obviously equals the $5,100 maximum. Now, if they are off on EPSLA leave for items 4, 5, or 6 from the prior slide, which relates more to care than to the employee's own condition, the maximum amount of pay is $200 per day or $2,000 in the aggregate. Again, remember, this particular act provides for 2 weeks or 80 hours of paid sick leave time. And just like with the FMLEA, the employer threshold, this only applies to employers that have 500 or fewer employees. Now, you heard me talk about schools, child care providers, and child care under both the FMLEA and the EPSLA. That's the only condition or situation in which an employee can potentially get the benefits of both of these acts. Under the EPSLA, you get the 80 hours of paid sick leave. Let's assume that you have an employee that's off because school is closed, which of course all schools in Ohio are closed right now, or a child care provider is unavailable. If it is an employee's child, son or daughter, then they would get that 2 weeks of pay. And again, this is only for full-time employees. And then they would also get the 10 additional weeks under the FMLEA, because you get a total of 12 weeks under the FMLEA, but only the last 10 weeks of those 12 weeks are paid. So when it's put together for employees with children out of school or because of a child care provider being unavailable, they can potentially gain these 12 weeks of paid leave subject to the aggregate maximum amounts for each individual law. So that is the only crossover between these two acts, and the Family Medical Leave Expansion Act only applies to this situation. So understand that the first one applies only to the school, child care provider, or daycare issue. The second one includes that same set of issues as one of 6 reasons why an employee can take up to 80 hours of paid leave. So put together at a maximum of 12 weeks paid leave. A little confusing, but nevertheless, you'll get used to it as you look at it. I hope I do too. Anyhow, moving on to phase 3. Now this is the big one where the big money comes into play, and it's one that came right out of the box, and people noticed the Paycheck Protection Program. Well, what I want to do is just walk through the law very, very briefly and let you understand that there are several divisions to this law. There are several named acts within this law, but you really don't care about all of that. What you want to know is, tell me about the Paycheck Protection Program. Tell me about the unemployment insurance provisions. As you can see on this page, those are listed in Title I and Title II of the CARES Act. And Section 1102 of Title I is the Paycheck Protection Program. And that is the law that is being debated in Washington, D.C., I hope, as we speak today, right now. And the debate is, will it be funded? Because it ran out of money very quickly. And there were so many applications that the SBA shut it down. So those are the different titles and divisions of the CARES Act. The ones we're primarily interested in relate to unemployment and, of course, the Paycheck Protection Program, because that is going to be a keystone to a lot of employers staying in business.
One more question, Bill, that just came up. If an employee has to take time off and we use the average hours of 2 weeks, do we have to use the most recent 2 weeks of work, or may we use 2 weeks where that employee had full hours? Some companies' hours have taken a hit due to issues with COVID-19.
It would be at their regular rate of pay under most circumstances. Amy, would you agree?
I would agree. And I think if you're willing to to pay more than the minimum, up to that maximum reimbursement rate, then I think that's probably okay. If you have an argument between an employee and employer, and the employee wants to be paid more because they used to work more hours, and the employer disagrees, then I think then you have to figure that out.
That's right. And understand that what we are working with right now is not the final information. And just to give you an example, for the Paycheck Protection Program, which is addressed on your screen right now, we got on the wee hours of the morning that it was first opened up for applications. The Small Business Administration issued preliminary regulations, and they were titled Interim Final Rule. I think that's the government's way of saying, we think this is pretty close, but we reserve the right to change these regulations. So as we sit here today, we don't have a final rule on the Paycheck Protection Program. And when I talk about a rule and regulations, those are made by the body that will enforce the law and distribute the money. And here it's the Small Business Administration. So again, we are very early in this process. We'll have more regulations and more explanation, and hopefully in the weeks that come. But this is literally trying to occur while bankers are looking at the regs and taking applications at the same time, and the regs aren't even final, they're interim final. So this slide talks a little bit about just the generic issues under the Paycheck Protection Program. Amy, if you'll move on to the next one. What you want to make sure you do under this program is follow all of the guidelines, do all of the paperwork, and don't leave yourself open to rejection just because of a paperwork error. Stay in touch with your lender and make sure that, and confirm and reconfirm that you have done everything possible under this law. Now let's move forward a little more. I don't want to take up all of the time here. Unfortunately, there's a lot to talk about. And also under Title II of the CARES Act are the references to the COVID-19 unemployment benefits. And here you can see three new acronyms, but just understand these are individual acts, again, under the CARES Act. They basically allow for self-employed gig workers and other folks who would not normally be covered at the state level where unemployment benefits are normally handled. They allow those folks to qualify for unemployment benefits. And the benefits are going to be increased by $600 a week through July 31st. Now, this is all subject to agreements between the states individually and the federal government. Governor DeWine has already signed the agreement. I have not seen it, but I have read that he has. So we can understand that folks in Ohio can expect the $600 per week kicker in their unemployment compensation. And you might be wondering, and we have experienced the situation ourselves where an employed individual is at work, considered an essential employee, and realizes that somebody else is taking home more money per week than I am, and I'm sitting here working. What's going on? And you have to explain, this is out of our control. This is a benefit issued by the federal government, the extra $600 per week, and it's nothing that the employer or the employee controls. This is an edict from the federal government. Now, that has not come into play yet, but the benefits will, as I understand, be retroactive back to when the employees became unemployed due to the COVID-19 crisis. So some of your employees are going to be making a lot more money on unemployment than they would be working, which is kind of a puzzling situation. So let's move forward. Jeff, were there questions about that you wanted to address?
No, I think that you worked through that question that came up.
Okay. Now, this part of the CARES Act relates to the money you'll receive directly. So I'm not going to go into this anymore. You can go back and look at the screen. Many of you have probably already received your $1,200 payment or $2,400 for joint tax filers. So if you haven't, I think you can expect to if you qualify. And if you have not received this, you might want to check as to why not. It's my understanding that these payments started to go out a couple of weeks ago. So if you haven't received it yet, be patient. I think within the next couple of weeks, you'll receive it. And with that, I think I've probably thoroughly confused you about the status of the COVID-19 crisis and the responsive laws. Now, what Amy is going to do is walk you through the top 10 employer questions and give you some answers, reasons, and resources for her answers. So Amy, if you'll take it away.
Thank you, Bill. I think it's really helpful to have all of that background so that we remember what laws we're talking about, where to go for these resources. So hopefully some of these questions are the same as what those of you watching are experiencing. These are the ones that we've heard the most. And some of them are the sort of the most confusing situations that we've been able to try to help our clients navigate. So one of the first questions we've been receiving is, in light of the pandemic, what health-related information can I ask employers or employees to provide to me as an employer? And the EEOC has provided some guidance on this and has said, in light of the fact that we are in this pandemic, you can ask employees if they're experiencing any of the known symptoms of COVID-19. We know that right now we know it includes fever, chills, shortness of breath, cough, sore throat. We also understand that it may include loss of taste or smell, and you can ask your employees if they're experiencing any of those symptoms and let them know that if they are, they should come to you and go home. And if you observe employees that you think are experiencing those symptoms, that's another way to ascertain whether your employees are safe or possibly sick. Next question we've heard a lot of is, may the employer take employees' temperatures before allowing them to enter the workplace? A lot of you, especially HR professionals, are pretty cued into the ADA and the fact that usually taking a temperature would be considered a medical examination, and you want to be careful about that. And that's the right approach, is to kind of be cautious. But because COVID-19 is considered a direct threat, according to the EEOC, you are allowed to take temperatures, but they also advise to be careful because some folks who have COVID-19 don't have a fever. They may have some other symptoms, or they may have no symptoms. So you have to kind of be on the lookout for anybody who could be susceptible to it, and also adhere to all of the social distancing and cleansing and all of that, all of the other rules that apply. You also need to remember that taking that temperature and keeping a record of it is considered a medical record. So keep those just as you would other employee medical records, keep them separate from their personnel files. And you'll notice some of these slides will have those links at the bottom, and those are the resources that we look to and that we always send to our clients too. So hopefully that helps you look those things up later when you happen to have these questions down the road. Next question we get a lot is, can I send an employee home if they exhibit symptoms of COVID-19? And the answer is yes. If you notice, or if they come to you and say, I'm experiencing symptoms, they should be sent home. Also advise them that they need to follow CDC guidelines. They should contact their healthcare provider and take care of themselves. I also recommend that you document what symptoms were observed and by whom, whether it was you that observed them, a coworker, or the employee, him or herself, what date it was that the employee was sent home, and then you can check in with the employee periodically and see if they're still experiencing symptoms. Also check on the CDC website if you haven't already for the criteria for letting those employees come back. Most people are not able to get a test for COVID-19, and so they're sort of presumptive cases. If they're not going to get a test, and their doctor has just said, it sounds like you have it, so you just need to stay home unless it's an emergency and then come in. But if they're able to ride it out, what you need to confirm with them before they come back is that they are fever-free for at least 72 hours, and their other symptoms have improved, like if they had a cough, that cough is improved, or shortness of breath, and it's been at least 7 days since their symptoms first appeared. So those are the criteria. That's also on the CDC website. It may also be in the stay home order. Next question, are employers required to allow employees to work remotely? That's a good question, and it may depend on what type of employer you are. According to Ohio's stay home order, non-essential businesses can still operate, but they have to do so remotely and certainly safely. For essential businesses, you're still encouraged to explore whether your employees can work remotely. But if it's not possible, if you're in manufacturing and you have to have employees on site, you have to modify your workplace according to those CDC and OSHA guidelines. They're also tracked in Ohio's amended stay home order, all of those guidelines about how to space people and what you should provide to your employees to keep them safe. Next question, number 5. If an employee reports being diagnosed with COVID-19, may I alert the rest of the workforce? Yes, you can, and I think you should, but there are some limitations to that. You shouldn't use the employee's name if you can help it. Some small workplaces it will be inevitable, but don't announce their name in a press release or on something that you post on the door going into the facility. What you should do though is provide information about the shift that they worked, the location or the building where they worked, and then what areas within that building may have been affected. And then I always think it's a good idea, transparency-wise, to tell your employees what your plan is for cleaning it, to make them feel better that you're going to make sure that they are safe and that you're handling the problem as quickly and as efficiently as you can. Now, if you know of other employees who were in direct contact with that employee who was diagnosed with COVID-19, you can also specifically go to them and see if they're experiencing symptoms. You can take their temperature, and if you're concerned, you can ask them to self-quarantine. Again, advise them to follow CDC guidelines and contact their healthcare provider to check in with them. This is a question that Bill referenced that has been one of the most prevalent we've heard, and that's employees who would rather stay home and collect unemployment, but the employer is an essential business and I have work for them, right? What should I do with that? So I've been telling lots of employers that this is your opportunity to have a really good conversation with those employees and explain a few things. The first thing I would say is talk to them about how you are keeping them safe at work. If you are requiring those employees to come in and they can't work remotely, show them what the CDC, what OSHA has a 25-page booklet, I believe, on preparing your workplace for COVID-19, and show them the stay home order paragraph, I think 18, about all the rules that you're required to follow and that you are following. They may have ideas about how to make the workplace safer. They may have ideas or suggestions about coming in at different times of day, adjusting a shift so that there's fewer people in the building, but you can also get work done. So that may resolve the conversation right there. If it doesn't, also explain to them that they are needed. The state of Ohio and many other states, including certainly Michigan, has certainly limited a lot of businesses from operating. And for whatever reason, your business has been deemed to be essential. And so those employees are needed to support the supply chain to keep things going. The last thing you need to talk to them about is if they are an essential worker who has essential work to do for their employer, they may not be eligible for unemployment to get that extra $600 a week. Because if they decide to stay home under those circumstances without any other reason to stay home, they probably would be considered to be leaving voluntarily, and that's how you would have to deem them. So you want to tell them they need to be honest if and when they apply for unemployment about why they're home. It's not for lack of work, and it's not for a COVID-19 reason. And you have to be honest in that response. And because of that, they may be taking a risk by staying home, because you're going to probably have to consider them to be, a voluntary resignation, for example.
Amy, if I can chime in on that last slide. Just as an example, I had an employer in a manufacturing setting have this very situation come up. And that employer wanted to help the employee and help the employee get benefits. And they asked me, well, can we write this down on our response to the Ohio Department of Job and Family Services? I said, the only thing you can write down in your response is the truth. Because you don't want to put yourself in a situation as an employer where you may be trying to help an employee, but you're not telling the truth on the forms. So I absolutely encourage all of you as employers to tell the truth and tell the Ohio Department of Job and Family Services exactly why that employee is not working at the current time.
I totally agree.
Yeah, you're the one signing it, so make sure it's accurate.
And us cynical lawyers always look to what are the problems going to be coming down the road. And I'm a little nervous about potential unemployment fraud claims. Are there going to be a lot of employees and guess who and potentially employers with deeper pockets that the state of Ohio or state of Michigan are going to come after, because they're starting to realize that all that money that went out the door, some of it wasn't going to people who didn't have work because of COVID-19. So just be honest, and that's all you can do. Okay, question number 7. What should an employer do if an employee wants to wear a face mask in the workplace? My general advice on that is let them, unless it's some sort of workplace hazard. It's been encouraged by Governor DeWine. Some industries and certain states may go to requiring them. And of course, the CDC is recommending that you should keep your mouth and nose covered when you're around. I've been to the grocery store lately, and about half the people had face masks on. I think it's going to be considered much more acceptable as we go, and I think that's what you want to think about. I was reading a little bit into this yesterday, and I want to caution anybody who's really familiar with OSHA guidelines and employers who are subject to OSHA when it comes to masks and safety in the workplace. OSHA has some pretty specific guidelines on certain types of masks. So if you're aware of those and you're trying to use a really specific type of mask, check into those OSHA guidelines or shoot us an email and we can help you through that. Now, here's an interesting question that we've started to hear is, do I have to provide the face mask as an employer? That's also sort of covered under the OSHA guidelines. If the employee is voluntarily wearing it, then you don't have to. But you might want to think about what type of mask you want to see on your employees, and is this a branding opportunity, or is this a way to make sure that everybody has a safe mask? And so if you want everybody to wear the same mask, I would suggest you go out and buy a bunch or make a bunch. A lot of people are making masks at home, and for the most part, most employers' sites are going to just require some of those cloth kind of make at home types. Okay, question 8. What documentation do I need from employees who request emergency paid sick leave or the expanded family medical leave? Every employee, the employer should be requesting the name of the employee requesting that leave, the dates for which leave is requested, the reason for the leave, and a statement from that employee that he or she is unable to work and why. If the employee is requesting leave because they're subject to a quarantine or an isolation order, you need to have the government entity that issued the order. Like Bill said earlier, we don't consider Ohio's amended or original stay-home orders to be quarantines or isolation orders. But if down the road there's a pocket or a municipality that issues some sort of isolation order that's more that would be more specific like that, that would be kind of what you would want to keep track of. For those employees requesting leave to self-quarantine based on the advice of their healthcare provider, you need at least the name of the healthcare provider who gave the advice. If your employer offers you their doctor's note, I would take it, because I think that's even better documentation. And it's always good to kind of get your ducks in a row now while all of this is pressure in your mind. I think 6 months from now, when we're trying to get reimbursement for some of these programs, we're going to be really grateful that we had a file with all of this information that we were gathering as we go. And finally, for those employees, this is probably going to be one of the more prevalent reasons for those employees who need to be off to care for their child. You need the name of the child being cared for, the name of the school, place of care, or child care provider that has closed, and the statement from the employee that no other suitable person is available to care for the child. And I see this reason that folks have to be home to care for their children or to homeschool their children. I think this is an opportunity for people to get a little bit more flexible about allowing their employees to either work remotely or work alternate schedules. If you have an employee who says, listen, I can keep working for you and I can come into the office if I have mornings at home to homeschool my child and my wife goes to work, and then I'll come in and my wife will come home and I'll work, you know, half shift or whatever it is, that may be a way for everybody to keep the business going. Allow your employees some flexibility so that they can keep their jobs and keep things going, and then not have to use up all that leave time. Okay, question 9. Does Ohio stay-home order count as as a qualified reason under number 1 in the Paid Sick Leave Act? You'll remember that when Bill talked you through all 6 of those reasons, the first reason is that an employee is eligible for emergency paid leave if they're unable to work due to the employee being subject to the federal, state, or local quarantine or isolation order. And as we've kind of already discussed, we don't consider Ohio stay-home order to be falling in that criteria unless the stay-home order caused you to be unable to work or telework, and you're still employed and your employer has work you could perform but for the order. That's found in, I guess, Department of Labor. If any of you guys are on that Department of Labor site that sort of expands on and has those questions and answers, that's in question number 60. That kind of threw us because the earlier questions seem to not include stay-home orders in that number 1 reason, but we think there's some sort of carve out for anybody in this situation. But if you are an essential worker who works for an essential business with work for you to do, we don't see that as somebody who has been caused to be unable to work, because the stay-home order allows essential work. So that's how we're interpreting that question. It's definitely come up a few times. In particular, one employer called me and said, I have one employee who is convinced that they qualify because of this reason. So we were able to kind of explain that it's not a quarantine and it's not an isolation order because you can still go get groceries. And those kinds of common sense examples sometimes help. Okay, last question. I employ fewer than 50 employees. Does the FFCRA apply to me? And the answer, first answer is yes. The FFCRA applies to all employers with fewer than 500 employees, including those who are usually not subject to FMLA because they have fewer than 50 employees, but there are exceptions. I don't need to read through all these reasons, but if you feel like your business is basically in jeopardy, if you honor the FFCRA mandated leave, then you need to be able to have an authorized officer of your business determine one of the following of these 3 items. And you'll see that information is, I think, taken directly from that Department of Labor website, Q&A numbers 4 and 59 through 58. 58 and 59, excuse me. Okay. Do we have additional questions that we can?
Yes, Amy, there were 2 that we didn't get to because you started in on the top 10 and I thought maybe you would answer them.
Okay.
I think the first one you kind of did answer along the lines of if someone is refusing to come back to work. And I think you said if they were essential and there is work for them, that they would be expected to come back in some way, shape, or form.
Mm-hmm. I think that's true. I've talked to a couple of employers, one in particular who allowed they were essential, but they sort of let as many employees as possible as wanted to go home during the very beginning of this pandemic because everybody was scared. So we decided that because the employer allowed that was sort of like a voluntary layoff. But at the point when the employer said, okay, I think we have a handle on this, we can't let anybody else leave, and actually our business is still going and we need some people back, at that point, we thought it was appropriate to say, if you still want to stay home, I'm telling you now, we have work for you to do. And so at this point in the timeline now, you're going to be determined to be a voluntary resignation, and that may deem you to be ineligible for unemployment at that point. So you can be fair with your employees, and they were bending over backwards to try to make everybody feel comfortable. But at a certain point, and because they were essential, they said, you know, we have business and we're going to lose a lot of business if we don't have some employees come back. So that's how we answered their question.
Okay.
I think the employees have to understand that unemployment compensation, even though it looks like the golden goose right now through the end of July with that extra $600 per week from the federal government, you're not automatically eligible for that. You still have to be eligible under the state laws and rules. And if you're telling an employee that you have work, they are needed, and they refuse, that, like Amy said, have the conversation with them that your unemployment isn't guaranteed, and we're going to fill out these forms honestly when we hear from the Ohio Department of Job and Family Services.
Okay. And then there was one other one. Some employees filed unemployment as full-time and their hours were cut to part-time. How would you handle that?
Go ahead, Amy.
Oh, I was just going to say, you may need to be able to kind of explain the timeline of that, whether if they were full-time up until March 15th or March 10th. Everything kind of hit. March 12th was the day that Governor DeWine said schools are not going to continue, and tomorrow's the last day. So Friday the 13th, everything kind of hit. You may just have to explain they were full-time until March 13th, and then after that they went part-time, and so here's the information.
And
It seems like that would
this
be.
is a good example of these laws are not standalone laws. You've heard us talk about a lot of different agencies and a lot of other laws. The Families First Coronavirus Response Act and the CARES Act impact a whole lot of agencies and a whole lot of other laws. And this is an example of where we would go to the Fair Labor Standards Act to look at what is the average weekly wage or what is the regular rate of pay. And we would have to look at some of the other laws to determine some of the answers under these new laws as they apply to COVID-19.
Okay, thanks. I'm going to unmute everyone. So if anyone else has another question, feel free to go ahead and ask it live. Any other questions for today? No? Julie, do you want to wrap us up?
Yes, Bill and Amy, thank you so much for that information and all the great questions that were answered. Just a reminder that there was a lot of information in those slides, and we want you to have access to those. So those will be available on RCO's website, as well as the Chamber's website under our member resources page. Additionally, give us just a little bit of time to download this presentation. We did record it, and that will be shared there as well. But again, thank you, Amy and Bill, for this great information and for being available for other Chamber members during this time to answer these questions.
We appreciate all you do for us and for the community as well. So thank you too.
Thank you.
Absolutely. Thank you.
Thanks, Julie.